Hello everybody, welcome back to the channel of Barrister Official, and in today's video we are going to discuss one of the landmark judgment of the Supreme Court, or you can say one of the most important and a crucial case law in the entire history of the constitutional law. The name of the case is none other than Kesavananda Bharati versus State of Kerala. So the importance of this case is very much in the prevalent situation or today's era cause in this case a lot many provisions and articles are contained that is going to understand make you clear that how the case is actually relating to the background and what is the relation of the fundamental right and the other thing. So without wasting any more time, let's begin with the video. So Keshavananda Bharati versus State of Kerala. Yeah. So in which year does this case took place? The year is 1973. Citation of this case law is okay. Citation of this case law is 1973 for SCC 225. Well, if you want to need a detailed video on citation, how to read the citation, you can do comment down below in the comment section. The court where the final hearing or the judgment was given, that court was the Supreme Court of India, the highest court. Well, moving forward, the bench. The many judges and justices were involved in hearing of this case, which include Justice, most important Justice Y.V. Chandrachud. You can read all the name of the justice and the judges who were involved in the case and who has given the most important judgment in the case of Keshavananda Bharati. So before directly plunging into the facts of the case, it is very much necessary for understand what were the background of the case during the time in which the famous case Keshavananda Bharati took place. So let's read out the content. After India got independence in the year 1947, as you all know that India got independence in the year of 1947, every state started looking forward for the improvement of their social and economic condition. The main point of doing this was the evolvement of society with due time and the requirement of a new law apart from the prevailing law. Well, why the state have started looking forward for the improvement of their social and economic condition because the society was evolving and there was a requirement of a new law at that time, like background back then after 1947, the peoples were well acquainted with their fundamental right. What is fundamental right? I guess you all know. uh, they are contained in the constitutional and are present in the article 12 to 35 as the realization of a certain rights were among the people. So at that time peoples were well aware of what were their fundamental right, what are the needs in the society. So they were acquainted with all these facts. So moving further, the system back then was such that the resources and the means of production were available to the certain people only, and the people soon started realizing that this concentration of wealth is not good. Well, back then the system was such that the resources and the means of production were available to the only certain peoples. मीन्स बस कुछ लोग थे जिनके पास रिसोर्सेज और मीन्स ऑफ प्रोडक्शन अवेलेबल थे, और जो बाकी लोग थे उन्हें ये रियलाइज़ होने लगा कि ये कंसंट्रेशन ऑफ वेल्थ जो कि कुछ लोगों के पास है ये ठीक नहीं है. टू चेंज दिस सिस्टम, every state started to change their prevailing laws, means to change the concentration of a wealth which were prevalent on a few peoples only. The state started changing their prevailing laws, the laws were which were already present in the case. Same was being done by the state of Kerala, which led to the importance case of the history of the constitution, and that is known as the Keshavananda Bharati versus State of Kerala. So I hope the background of a case is clear to everyone. So why the state were looking forward for the changing of the law? This was because to eradicate the concentration of wealth. Well, facts of a case. There exist many laws in the state of Kerala, such as zamindari system, land ownership, tenancy law, and many other substituting law. To improve the system, Kerala government passed the Land Reform Act. This Land Reform Act put the restriction on the people as to who can own how much amount of land. Means to improve the prevailing land laws, the Kerala government passed the Land Reform Act. तो ये लैंड रिफॉर्म एक्ट क्या करती थी? दिस लैंड रिफॉर्म एक्ट पुट्स द रेस्ट्रिक्शन ऑन द पीपल एज टू हु कैन ओन हाउ मच अमाउंट ऑफ लैंड. मीन्स कौन कितने अमाउंट ऑफ लैंड को ओन कर सकती हैं, ये लैंड रिफॉर्म एक्ट उसे जज करता था. दिस एक्ट रेस्ट्रिक्टेड द प्रॉपर्टी राइट. वेल, प्रॉपर्टी राइट इज़ वन ऑफ द मोस्ट इम्पॉर्टेंट राइट of the citizen of India, and this act restricts the property right of an individual. Using this act, the state government acquired the land of Adnirmat. Adnirmat situated in the Kasargod district of Kerala. Due to this overtake by the government, income ceases to generate for the Adnirmat, which eventually causes hardship to the authority of the Mutt for the efficient running. Hence, this land acquisition was challenged by the head of the Mutt, popularly known as Sri Keshavananda Bharati. Means basically the Land Reform Act restricted the property right of the people, and hence the state government acquired the land of एडनीर मठ. और एक्विजिशन से क्या हुआ? एडनीर मठ के पास जो इनकम जनरेट होते थे बिकॉज ऑफ द अवेबिलिटी ऑफ लैंड, दिस सीजेस टू जनरेट. मतलब उनका इनकम वो उतना नहीं होने लगा. तो उसी के कारण द हेड ऑफ द मठ, दैट वाज केशवानंद भारती, filed a writ petition in Supreme Court against the Land Reform Act. This case was represented by the eminent lawyer of that time, Nani Palkiwala. So, if anyone can say what is Nani Palkiwala, well, he was a legend of lawyer after the, Ramjet Malani. The name of Nani Palkiwala is there in the name of a history. Well, no one can compare his legacy and no one can come to his level. Well, the Kesavananda Bharati case was represented by the eminent lawyer of that time, and he was Nani Palkiwala. At that time, many such cases were going on in the parliament. With the similar nature of a cases, many cases were there, such as bank nationalization case, Madhav Rao, SC India case, Golak Nath case. In all these cases, one thing were very common, that is strong parties that were power struggling. Strong parties in all these cases, two strong parties that were power struggling were Parliament and Supreme Court. Well, in all these cases, two parties that were power struggling was the Parliament and the Supreme Court. The Parliament says that Article 368, power of a Parliament to amend the Constitution and the procedure thereof, gives Parliament unlimited power to amend the Constitution, but Supreme Court was not agreed with this statement. Therefore, in the case of Golak Nath versus State of Punjab, in case of Golak Nath versus State of Punjab, 11 judges bench were constituted, and question came that whether Parliament has unlimited power to amend the Constitution or not. After evaluating the material fact, the Supreme Court restricted the amending power of the Parliament. So, in case of Golak Nath versus State of Punjab, the Supreme Court put the restriction on the amending power of the Parliament. So, you can note this point because this is going to overrule in the case of Kesavananda Bharati. So there were many important amendments relating to this case. So basically hui kya, when the Supreme Court in the Golak Nath versus State of Punjab jab ye restrict kar di amending power of a Parliament, so Parliament to remove those restrictions came up with the three amendments. जब पार्लियामेंट को अपनी अमेंडिंग पावर को रेस्ट्रिक्ट कर दिया गया तो पार्लियामेंट 3 अमेंडमेंट एक्ट के साथ आती है, 24th Amendment Act, 25th Amendment Act and 29th Amendment Act. The importance of this amendment act are very much crucial as you are going to learn in the upcoming content. 24th Amendment Act. This act gave the Parliament power to amend the fundamental right along with the fundamental right. Any provision of the Constitution can also be amended as stated in this act. 25th Amendment Act. This Amendment Act gives us a vivid idea that the right of property can be curtailed. However, compensation will be provided for the same. The amount of compensation will further be decided by the Parliament. 29th Amendment Act. According to this act, land reforms were put under the Schedule 9. Means if any act is under the Schedule 9, judicial review can't be done for the same. The 9th schedule contains the laws of the center and the state which cannot be amended. Further judicial review of this law can't be done. Well, there were the most important issues which was raised in this question. The first issue was, do Parliament has the unlimited power of amending the constitution? क्या Parliament के पास अनलिमिटेड पावर है कॉन्स्टिट्यूशन को अमेंड करने का? कैन पार्लियामेंट अमेंड द फंडामेंटल राइट? बिकॉज इट्स अ बेसिक फीचर एंड एवरी इंडिविजुअल और द सिटीजन ऑफ इंडिया इज एंटाइटल्ड टू देयर फंडामेंटल राइट. पार्लियामेंट, अगर पार्लियामेंट के पास अनलिमिटेड पावर है अमेंड करने का कॉन्स्टिट्यूशन को, देन टू व्हाट एक्सटेंट दे कैन अमेंड द कॉन्स्टिट्यूशन? सो we will discuss now what were the argument from the petitioner side as well as from the respondent side. Well, the argument from the petitioner side, the petitioner argued that the right under the article, petitioner here in the case is Kesavananda Bharati. Kesavananda Bharati. I hope you all are well aware of who are petitioner and who are respondent. The petitioner argued that the right under Article 1491 F 25 and 26 has been violated because of the Land Reform Act. According to the petitioner, the right to own and manage the land is a fundamental right of an individual and therefore it cannot be violated by the Land Reform Act. They say that right to own and manage the land is the fundamental right and it cannot be violated by the Land Reform Act. The Parliament need to protect these rights rather than curtailing them. Yes, Parliament has to protect these rights rather than curtailing them. Then how the hell they are curtailing this right? In the Constitution, Article 368 is not absolute, but it is restricted and limited, and Parliament cannot change the provision of the Constitution arbitrarily. Arbitrarily means मनमानी से जो मनाए वो कर देना. Furthermore, they argue that rights given in the Constitution are to protect citizens' freedom. Example, Article 91 F talks about right to property and the right of the citizen cannot be curtailed by the Land Reform Act. The 24th and 25th Amendment Act, which the Parliament has brought against the fundamental right of the citizen. Well, we will now discuss what were the argument from the respondent side. They argue that the Parliament has absolute and unlimited power to amend the Constitution. Means the respondent argued that the Parliament do have absolute and unlimited power to amend the Constitution. Cool. According to them, every state has to improve its social and economic condition. In that situation, there must not be any kind of a restriction, because if there will be a restriction, then with due time new needs of the society cannot be fulfilled. Means every state has to change their law, and if there will be a restriction prevailing on the state, then with due time the new needs of the society cannot be fulfilled. They further argue that the Parliament has the power to put restriction on the fundamental right. Well, they argue that the Parliament has the power to put restriction on the fundamental right as well. Well, now we will discuss the judgment. The judgment in this case were delivered by the 13 judges bench. These were the highest number of judges bench ever in the history of a constitution till date. Largest bench ever, and the decision came up in 7:6 majority. So you can see which judges and justices gave the majority as well as minority judgment. In the case of Golak Nath versus State of Punjab, it was held that the Parliament cannot amend the fundamental right, but the judgment in this case overruled. Now you can relate. Earlier, I have said that the judgment of the Golak Nath versus State of Punjab will be overruled in this case, and hence it was being done. Fundamental right. It was held by the it was held that the Parliament cannot amend the fundamental right in the case of Golak Nath versus State of Punjab. This case overruled the previous judgment of the court. This judgment of this case held that the Parliament does have a power. Parliament does have a power to amend the fundamental right. The 24th Amendment Act, which was challenged by the petitioner, was also held valid. 24th Amendment Act को भी valid held किया गया and was said that the Parliament can amend the provision of the Constitution. Also, the Supreme Court held that the Parliament has a power to amend the Constitution under the Article 368. However, the extent of Parliament was also given within which only they can amend the provision of the Constitution. The Supreme Court said that although the Parliament has a power to amend the provision of the Constitution, still the Parliament cannot interfere with the basic feature of the Constitution. Means the Parliament cannot interfere with the basic feature of the Constitution. In the 25th and 29th Amendment Act was also held valid. So the Parliament came up with the three Amendment Act, that is 24th, 25th and 29th. All of them were held valid in the case of Kesavananda Bharati versus State of Kerala. It was also featured that the Constitution in the case of judicial review of that case on 24th April 1973. This landmark judgment introduced the basic doctrine structure, and the case of Kesavananda Bharati versus State of Kerala is also known as Basic Structure Doctrine case. So yeah, finally, to conclude our topic from the discussion, we can conclude the fact that earlier in the Golak Nath case, it was held that the Parliament do not have a power to amend the Constitution, but the decision was overruled in the case of Kesavananda Bharati that they can amend the Constitution. This case is very much crucial in the history of a judiciary and serve for the purpose of the judicial precedent in many cases, even in the modern era. This landmark judgment hold the supremacy of the Constitution as a given idea on how it works. Well, this was the entire case analysis of Kesavananda Bharati versus State of Kerala, the most important case of the constitutional law, as well as it serves as the purpose of judicial precedent in other laws as well. I hope you have understood the entire case analysis of Kesavananda Bharati versus State of Kerala. The entire case analysis is written by me and it is not plagiarized anyway, so you can completely rely on this content. Thank you everyone for watching this video. For more such videos, do subscribe to the channel of Barrister Officials. Thank you.